Welcome to section 19.1, part 1. This is the 193rd session of the CISSP exam prep series. In this session, we'll open the world of security investigations. We'll answer several questions. Why does an incident sometimes turn into a formal inquiry? What are the 4 investigation types you must know? How does evidence get exchanged before a trial? What makes evidence admissible in court? And what forms can that evidence take? Why does this matter beyond the exam? Because the day you mishandle evidence is the day a case falls apart. Imagine a retailer discovers a payment terminal was tampered with. If you seize that terminal carelessly, a court may throw out everything you found, handle it correctly, and your work stands up under scrutiny. You are the person who decides which of those futures happens. Why does a routine incident sometimes become a formal investigation? Because the stakes are not always small. Many incidents are minor enough to close with a quick judgment call. But when the damage or the threat is serious, you need a rigorous inquiry. The moment it turns formal, procedure becomes everything. Sloppy steps can violate someone's rights, sink a prosecution, or expose you to legal action. Picture a small kitchen fire versus a full arson case. One you handle yourself, the other demands careful documentation. What are the main types of investigation you need to recognize? There are 4 big ones, and each carries its own standard of proof. Administrative investigations look inward at operations and policy. Criminal investigations pursue alleged violations of criminal law. Civil investigations resolve disputes between 2 parties. And regulatory investigations handle possible breaches of administrative law. Think of them as 4 different courtrooms, each with its own bar to clear. Match your rigor to the room you are heading toward. What is an administrative investigation? It is an internal inquiry into operations or a policy violation. Sometimes it is pure troubleshooting, like tracing why a fleet of servers keeps slowing down. That is an operation investigation, and it carries the loosest evidence standards because the goal is simply to fix the problem. These often include a root cause analysis to stop the issue from returning. But watch closely. An operational dig can suddenly uncover an intrusion and flip into a criminal case. When an administrative matter may end in sanctions against a person, you raise the standard and consult your legal team early. What sets a criminal investigation apart? Its stakes are the highest, so its evidence rules are the strictest. These are usually run by law enforcement and can end with charges and prosecution. Most criminal cases must meet the beyond a reasonable doubt standard. That means the facts must leave no other logical conclusion than guilt. Because of that towering bar, collection and preservation have to be flawless. Think of it like building a bridge that must hold enormous weight. Every bolt has to be traceable and tight. How is a civil investigation different? It clears a lower bar, so its rigor is lighter. Civil work usually skips law enforcement and relies on internal staff and outside consultants supporting a legal team. The goal is to resolve a dispute between 2 parties in civil court. Here the standard is preponderance of the evidence, not reasonable doubt. You only need to show the outcome is more likely than not. Picture a tug of war where the rope only has to lean one way. What happens in a regulatory investigation? A government agency steps in when it suspects a violation of administrative law. Regulators set their standard of proof to match the venue where they expect to argue the case. These inquiries vary widely in scope and are often run by government agents. And here is a twist. Some regulatory-style investigations involve no government at all. They flow from industry standards, like the rules that protect payment card data. Those rules are contracts, not laws, but failing an audit under them can still bring fines. Treat an industry-standard probe with the same seriousness as a government one. How does evidence get shared before a case reaches court? Through a process called discovery, where each side must preserve and exchange relevant information. When that information lives in digital form, we call it electronic discovery. There is a widely used reference model that lays out this work in 9 stages. It moves from governing your information and identifying what is relevant through preserving, collecting, and processing it, then into review, analysis, production, and finally presentation. Think of it as a factory line that turns a mountain of raw data into a clean, court-ready exhibit. It demands tight teamwork between your technical staff and your lawyers. What makes evidence admissible in a court of law? A judge weighs it against 3 tests before it ever reaches open court. First, it must be relevant, meaning it helps establish a fact. Second, that fact must be material, meaning it truly connects to the case. Third, the evidence must be competent, meaning it was obtained legally. Evidence pulled from an illegal search fails that last test and gets tossed. Picture a bouncer at a door checking 3 items before anyone walks in. Miss one, and you stay outside. What forms can evidence actually take? You should know 4 major categories. Real evidence is a physical object you can carry into the room, like a seized laptop. Documentary evidence is written material offered to prove a fact, like a system log. Testimonial evidence is what a witness swears to under oath. And demonstrative evidence is a visual aid that helps explain a concept to a jury. Think of them as 4 different tools in a toolbox, each suited to a different job. Each category also carries its own extra rules for getting in. What counts as real evidence, and how do you prove it is genuine? Real evidence is a tangible object brought before the court, from a keyboard with fingerprints to a suspect's hard drive. But an object alone is not enough. It must be authenticated as unique and unaltered from the moment of collection. When no witness can personally vouch for it, you rely on a chain of custody. That chain documents every single hand the item passes through, with time, date, location, and reason logged at each step. Everyone who touches it signs off. Picture a relay baton that can never be dropped or swapped. An unbroken chain is what keeps that object credible. What special rules govern documentary evidence? Written material must clear 2 extra hurdles beyond the basic tests. The best evidence rule says you generally must produce the original document, not a copy or a summary. The parole evidence rule says that once an agreement is written down, that written version holds all the terms, and no side deal spoken aloud can change it. There is also a catch with documents. A log usually needs a witness, like the administrator who kept it, to confirm it was captured as normal business practice. Think of it like a sealed original contract in a safe. The photocopy on your desk simply does not carry the same weight. What is testimonial evidence, and where are its limits? It is simply what a witness tells the court, spoken live or captured in a sworn deposition. Every witness takes an oath and must speak from personal knowledge, though they may glance at notes to jog their memory. Most witnesses are held to direct evidence, meaning only what they themselves observed. There is one important exception. A person the court accepts as an expert may offer an opinion built on the facts and their deep field knowledge. Think of the difference between a bystander who saw the crash and an engineer who can explain why the brakes failed. So let's bring it together. Investigations turn formal when the stakes rise, and each type carries its own standard of proof, from loose administrative work to strict criminal cases. Before trial, discovery moves evidence between the parties, with electronic discovery running through 9 defined stages. To be admissible, evidence must be relevant, material, and competent, and it arrives as real, documentary, testimonial, or demonstrative, each authenticated by rules like the chain of custody. Master these foundations, and the hands-on forensics ahead will click into place. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to Section 19.1, Part 2. This is the 194th session of the CISSP Exam Prep series. Having covered investigation types and the forms of evidence, we now turn to the rules and hands-on techniques of digital forensics. In this session, we'll get practical about handling digital evidence. We'll answer several questions. Why can't a witness repeat what someone else told them? How do you support testimony with a visual aid? What principles guide anyone who touches digital evidence? How do you analyze disks, memory, networks, and devices without corrupting them? And why does every attack leave a trail? Why does this matter beyond the exam? Because one careless click can destroy the very proof you need. Suppose a manufacturing firm suspects an engineer stole design files onto a thumb drive. If you plug that drive into a live machine and browse it, you may overwrite the timestamps that prove the theft. Do it right, and the evidence stays pristine. The techniques ahead are what separate a solid case from a wasted one. Why can't a witness simply repeat what someone else told them? Because of the hearsay rule. A witness generally cannot testify about statements made outside of court, since the court has no way to test them. But this rule is famous for its many exceptions. The one that matters most to us is the business records exception. It lets records like system logs come in as evidence when they were created at the time of the event, kept in the normal course of business, and maintained as a regular practice. A qualified person still has to confirm those conditions. Think of a log as a diary the system writes automatically, day after day, without an agenda. How do you support a witness with a visual aid? You use demonstrative evidence. This is material that helps a witness explain a concept or clarify a confusing point. It may not be admitted as proof itself, but it makes the testimony land. A diagram of how a flood of traffic overwhelmed a server can turn a tangle of jargon into something a jury actually grasps. The trial court decides whether to allow it, guided by one simple test. Does it genuinely help people understand the case? Picture a whiteboard sketch that finally makes a hard idea click. What principles guide everyone who handles digital evidence? A respected body laid out 5 that anchor the whole discipline. First, seizing evidence should never change it. Second, only a forensically competent person should touch the original. Third, every action taken with the evidence must be fully documented and available for review. Fourth, whoever holds the evidence is responsible for everything done to it. And fifth, any organisation involved must comply with all of these rules. Think of them as 5 laws of a clean room. Break one, and you contaminate the sample. Why should you work from a copy instead of the original? Because the act of investigating can itself alter the evidence. Every time you open a file or run a tool, you risk changing what you are trying to preserve. So the golden habit is to duplicate first and analyze second. When you examine a hard drive, you make an image of it, seal the original in an evidence bag, and dig through the copy. Picture an archaeologist casting a mold of a fragile artifact and studying the cast, leaving the original untouched behind glass. How do you analyze storage media safely? Media analysis is the extraction of information from disks, tapes, and optical media. The cardinal rule is to never touch a live system's drive. Instead, you power the machine down, remove the storage device, and attach it to a dedicated forensic workstation through a write blocker. A write blocker is a hardware adapter that physically prevents any data from being written back to the device. Then you calculate a cryptographic hash of the contents, create a bitwise forensic image, and hash that image to prove the two match. Think of the hash as a tamper evidence seal. If the numbers ever differ, you know something changed. How do you capture evidence from a live system's memory? This is in-memory analysis, and it is delicate because reading memory can alter it. You use trusted tools to generate a memory dump and write it to a forensically clean device, like a prepared USB drive. That dump captures everything held in memory at that moment for later study. Just like with disks, you compute a cryptographic hash of the dump to prove its authenticity, then work only from copies. Picture trying to photograph a sandcastle before the tide comes in. You have to capture it quickly and gently, without disturbing a grain. How do you reconstruct what happened across the network? Network analysis is tricky because network data is volatile. If activity is not deliberately recorded when it happens, it usually vanishes. So this work leans on controls, already logging traffic, like intrusion detection systems, flow monitors, packet captures, and firewall logs. To capture live traffic without disturbing it, you use a mirror port on a switch or a hardware network tap. Both copy the traffic for analysis without altering the real conversation between systems. Then you hash and copy the captures like any other evidence. Think of a tap as a one-way window. You watch everything, but the room never knows you are there. What does software analysis involve? It is the forensic review of applications and the activity inside them. When an insider is suspected, an analyst may comb through source code for hidden backdoors, logic bombs, or other planted flaws. In other cases, they read application and database logs hunting for signs of attack, like injection attempts or privilege escalations. Software analysis also includes checking file hashes against a giant reference library of known good files, which quickly flags anything that has been tampered with. Think of it as comparing a suspect file's fingerprint against a national database of trusted ones. A mismatch tells you the file is not what it claims to be. How do you handle hardware and embedded devices? Analysts are often asked to examine everything from personal computers and smartphones to the embedded chips inside cars and security systems. These reviews demand deep, specialized knowledge of the device's memory, storage, and operating system. So an organization may need to bring in expert consultants because software, hardware, and storage interact in complex ways here. This discipline blends the skills of both media analysis and software analysis. Picture a mechanic who also has to be an electronics engineer to diagnose a modern car. One skill set alone is not enough. Why does every attack leave a trail? Because of a foundational idea in forensics that every contact leaves a trace. When two objects meet, something is exchanged, whether a fingerprint, a fiber, or a log entry. Digital forensics experts believe this holds true online too. Trace an intrusion and you find footprints everywhere it passed. Consider an attacker who injects malicious commands into a website. Their own device carries tools and logs. The network they used records their connection. The firewall and web server capture the malicious requests, and the database logs the commands that ran. Each contact point is a witness. Think through the full path of an attack, and you uncover a chain of evidence you would otherwise have missed. So let's bring it together. The hearsay rule blocks second-hand testimony, but the business records exception lets system logs in. Demonstrative evidence helps witnesses explain, while 5 core principles keep digital evidence clean, starting with never changing the original. You work from copies, use write blockers and hashing on disks, capture memory and network traffic gently, and review software and hardware with specialized skills. And through it all, remember that every contact leaves a trace. Carry these habits, and your findings will hold up when it counts. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to Section 19.1, Part 3. This is the 195th session of the CISSP Exam Prep series. With the forensic techniques behind us, we now walk through running an investigation from start to finish. In this session, we'll cover the mechanics of an actual investigation. We'll answer several questions. How do you set up an investigation properly? What are the lawful ways to confiscate evidence? Do employees have privacy at work? When should you call in law enforcement? How do you conduct the inquiry and interview people? And how do you protect and report your findings? Why does this matter beyond the exam? Because a well-run investigation protects both the truth and everyone involved. Imagine a logistics company that suspects an employee is leaking shipping data to a rival. If your team acts without a clear mandate, you risk overstepping, tipping off the suspect, or violating their rights. A disciplined process keeps the inquiry fair, defensible, and effective. That discipline is what turns suspicion into a solid conclusion. How do you set up an investigation the right way? You start by assembling a team of competent analysts. That team should work under your existing incident response policy and receive a clear charter. The charter defines the scope of the inquiry, the authority and roles of the investigators, and the rules of engagement they must follow. Those rules spell out what actions the team may take at each phase, like when to call in law enforcement, collect evidence, or cut off system access. Think of it like handing a search party a map, a radius, and a clear list of what they're allowed to do. Without that framing, people improvise, and improvisation gets cases thrown out. What are the lawful ways to confiscate evidence? There are 5 you should know, and choosing wrong can ruin your case. First is voluntary surrender, which works best when the person is not the guilty party, since few suspects hand over what will incriminate them. Second is a subpoena, a court order compelling someone to produce evidence, though it also warns them in advance. Third is the plain view doctrine, where an officer may seize evidence sitting in plain sight during a lawful duty. Fourth is a search warrant, reserved for when you must act without tipping off the owner. And fifth is exigent circumstances, where an officer may search without a warrant because evidence would otherwise be destroyed or someone is in danger. Picture 5 different keys, each cut for a specific lock. Use the wrong one, and the door stays shut. Do employees have privacy at work? Usually far less than they expect. Outside government workplaces, most jurisdictions hold that employees have little expectation of privacy on company systems. Employees generally have the right to search the electronic systems they own and operate. You can strengthen this with a smart habit. Have new hires sign an agreement consenting to search and seizure as a term of employment. That consent makes confiscation faster and reduces lost evidence while you wait for permission. But the moment a search reaches into someone's person or personal belongings, the law gets complicated, so bring in an attorney. Think of it as the difference between opening a company-owned locker and searching someone's backpack. When should you call in law enforcement? This is a weighty decision that belongs to senior management. On one side, the experts bring real firepower. National agencies run dedicated cybercrime units with agents trained specifically for these cases, and they can coordinate with local police. On the other side, two forces push companies to hesitate. An investigation may become public and embarrass the organisation, and once law enforcement is involved, they must follow constitutional limits that would not bind a private inquiry. One of those limits is the warrant requirement, and it deserves a closer look. Picture calling in the fire department. They put out the blaze expertly, but they also file a very public report. Why do search warrants matter so much? Because they set the rules for when the government may search. A warrant must be built on probable cause, meaning real evidence that a crime occurred and that the search will reveal proof of it. That bar is much lower than what a conviction requires, and warrants are often granted on an investigator's sworn testimony alone. A warrant must also be specific, describing exactly what may be searched and seized. Miss even a small detail, and a court can invalidate the warrant and throw out everything it produced. Picture a permission slip that only covers one room of a building. Step outside those walls, and the evidence you gather does not count. How do you conduct the investigation itself? Carefully, whether or not law enforcement is involved. A few principles keep you safe. Except when capturing live memory. Never run your investigation on the compromised system itself. Take it offline, make a backup, and work from that backup. Never try to hack back and retaliate, or you may strike an innocent party and face charges yourself. And if you are ever unsure, call in expert help. Whether law enforcement or a private forensics firm, think of a crime scene photographer who documents everything but never rearranges the room. Your job is to preserve, not to disturb. How do you talk to people involved in a case? It depends on your intent, and the distinction is legally important. If you are simply gathering information to help your inquiry, that is an interview. If you suspect the person of a crime and plan to use their words in court, that is an interrogation. Before either one, plan your topics with a checklist so different subjects are questioned consistently, then adapt as the conversation reveals more. These are specialised skills that belong to trained investigators, because clumsy technique can wreck a future prosecution. Many laws also govern detaining people, so always consult an attorney first. Think of the difference between a friendly chat and a formal deposition. The stakes are worlds apart. How do you protect evidence and its integrity over time? 2 ways, and both matter. First, guard the integrity of evidence during collection, because altering it even slightly can get it thrown out. Second, protect the data before you ever collect it, since many incidents are discovered long after the fact. A key log that could unmask an attacker is useless if it was purged first. Attackers often try to wipe logs to cover their tracks, so send log records to a locked-down central server that does not allow changes. Digital signatures can prove logs were not altered after capture, and a simple archiving policy keeps evidence available no matter how old the incident. Picture a security camera that streams footage to an off-site vault the moment it records. How do you close out an investigation properly? With a final report and a standing relationship. Every investigation should end in a report documenting the goals, the procedures followed, the evidence collected, and the results. Formal documentation matters because you rarely know at the start whether a case will end up in court, and even an internal matter can become a legal dispute. Standard procedures and checklists keep your evidence admissible down the road, and everyone involved should be properly trained. Build a relationship with your legal team and law enforcement contacts before you need them, and name a single liaison to speak for your organisation. When trouble hits, That groundwork saves precious time. Picture exchanging numbers with your neighbors before the storm, not during it. So let's bring it together. A sound investigation starts with a team, a charter, and clear rules of engagement. You confiscate evidence through one of 5 lawful paths, remembering that workplace privacy is usually limited. Calling in law enforcement is a management decision with real trade-offs, and warrants must rest on probable cause and stay specific. You investigate from a backup, never hack back, and know when a conversation is an interview versus an interrogation. Finally, you protect evidence integrity, retain your logs, and document everything in a final report. Follow this arc, and your investigations will stand up to any scrutiny. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to section 19.2. This is the 196th session of the CISSP Exam Prep series. In this session, we'll map the motives behind computer crime. We'll answer several questions. What actually counts as a computer crime? What are the 7 categories you must know? What is each attacker really after? How does an attacker's skill shape the evidence they leave? And why does understanding motive help you defend? Why does this matter beyond the exam? Because knowing why someone is attacking tells you how to stop them. Picture a regional utility, an online retailer, and a political non-profit. Each faces a completely different kind of adversary. When you understand what an attacker wants, you can predict their moves and harden the right targets. Defending blindly wastes effort. Defending by motive puts your energy where the threat truly is. What actually counts as a computer crime? Simply put, it is any crime that involves a computer. The machine might be the target of the attack, or it might be the tool used to commit the offense. Here is the framing that matters. The motives behind computer crime are no different from the motives behind any other crime. Greed, revenge, ideology, and thrill drive both. Only the method changes. Remember too that anyone who violates your security policy counts as an attacker. Think of a burglar who now picks digital locks instead of physical ones. The intent is old, but the toolkit is new. What are the categories of computer crime you need to know? There are 7, and each represents a different purpose behind an attack. Military and intelligence attacks chase secret information. Business attacks target a company's data and systems. Financial attacks pursue money. Terrorist attacks aim to disrupt and instill fear. Grudge attacks seek revenge. Thrill attacks are done for the fun of it. And hacktivist attacks push a political cause. Think of these as 7 different reasons someone breaks a window. Naming the reason tells you what they came for. What drives a military and intelligence attack? The hunt for secret and restricted information. Attackers go after military plans, sensitive intelligence, or details of criminal investigations, often as a prelude to a bigger strike. Because these targets are so valuable, they draw the most skilled adversaries, which is why such systems carry stringent perimeter and internal controls. There is also a modern face to this threat, the advanced persistent threat. These attackers are well-funded, highly skilled, and backed by a nation-state or organized group, and they focus relentlessly on one target. The most dangerous ones cover their tracks so well that you never even know they were there. Picture a spy who slips in, copies the file, and leaves no fingerprint. What is a business attack after? A company's confidentiality, integrity, or availability. Sometimes the goal is theft of confidential information, like a secret formula or sensitive employee data, and the damage often comes later when that information is used against you. This is corporate espionage, and it has taken on a sharper edge as state-sponsored actors join the game. Other business attacks target integrity or availability instead. Ransomware is the classic example. It locks up your own data and holds it hostage until you pay to get it back. Picture a rival who either steals your recipe or padlocks your kitchen. Either way, the business bleeds. What is a financial attack trying to gain? Money or services? Plain and simple. These are the crimes you hear about most in the news, from stolen card numbers to fraudulent transfers. You can often gauge an attacker's skill by the size of the theft. Small-time attackers chase easy targets. but even tiny amounts skimmed from countless transactions can pile into millions. There is also a mercenary version, cybercrime for hire, where attackers run attacks on behalf of paying clients. A common product is the rented botnet, a network of hijacked machines leased out to flood a target and knock it offline. Picture a getaway driver who does not care about the heist, only the fee. What makes a terrorist attack different? Its goal is not information but disruption and fear. Where an intelligence attack quietly steals secrets, a terrorist attack aims to upend normal life. Intelligence gathering often comes first, so a system hit today may have been quietly compromised earlier. The frightening targets are the systems that run power plants, telecommunications, and the electrical grid, many of which are computerized and exposed. Imagine a coordinated strike that pairs a physical attack with a cyber attack that knocks out power and communications at the same moment. Your ability to respond would be crippled just when you need it most. Vigilant monitoring is what lets you catch the early moves. What fuels a grudge attack? Resentment, pure and simple. The attacker wants to damage a person or an organization, whether by destroying data, crippling systems, or wrecking a reputation. The classic culprit is a recently fired employee out to get even, or someone nursing a personal grievance. This is where the insider threat bites hardest. A departing administrator who still holds active accounts can do enormous harm, especially if your deprovisioning process is slow. Not every insider incident is malicious either, since a privileged user's simple mistake can open the door for an outside attacker. The defense is diligent monitoring, tight vulnerability assessments, and cutting off access the instant someone leaves. Picture handing back the keys, but the locks were never changed. What is behind a thrill attack? The simple rush of breaking in. These attackers often lack the skill to build their own tools, so they download ready-made programs and run them. That earns them the nickname script kiddies, because they only execute other people's scripts. The usual outcome for a victim is a service interruption, or a compromised system used to launch the next attack. A common signature is website defacement, where the attacker replaces your legitimate pages with content boasting about the break-in. Automated tools let a single unskilled attacker deface an enormous number of sites in a very short span. Picture a vandal spray painting walls just to prove they got past the fence. What sets hacktivists apart? They fuse politics with the thrill of hacking. Hacktivists combine the words hacker and activist, and they organize loosely into named collectives. Their aim is to disrupt organizations they disagree with philosophically. Using automated tools, they can launch large denial-of-service attacks that overwhelm a target with traffic, and they need surprisingly little skill to do it. What makes them notable is the cause, since the attack is a form of protest rather than personal gain. Picture a crowd blocking the entrance to a building to make a statement. The disruption is the message. So let's bring it together. A computer crime is any crime involving a computer, driven by the same old motives with a new toolkit. The 7 categories map those motives. Military and intelligence attacks steal secrets. Business attacks target company assets. And financial attacks chase money. Terrorist attacks sow fear. Grudge attacks seek revenge. Thrill attacks chase a rush. And hacktivists push a cause. Read the motive, and you can predict the moves. That insight is what lets you defend the right assets before an attack ever lands. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to section 19.3. This is the 197th session of the CISSP Exam Prep series. In this session, we'll explore the ethics that govern our profession. We'll answer several questions. Why do ethics matter so much in security? What does an organizational code of ethics look like? What does the code of ethics demand? How are ethics complaints handled? What new questions does artificial intelligence raise? And which classic frameworks still guide digital conduct? Why does this matter beyond the exam? Because your role hands you extraordinary access. And access without ethics is dangerous. Imagine you can read every executive's email, unlock any door, and watch every keystroke. A code of ethics is what keeps that power in check and earns the trust your job depends on. Employers grant you the keys to the kingdom only because they believe you will not abuse them. Ethics is the promise behind that belief. Why do ethics matter so much in security? Because you occupy a position of deep trust. Ethics are the moral rules that guide your conduct, the standards you hold yourself to when no one is watching. In business, they shape how an organization acts fairly across everything from finances to conflicts of interest. In security, they ensure professionals act responsibly given the sensitive systems they control. Remember that these codes are not laws. They are minimum standards of behavior, a floor beneath your judgment rather than a ceiling. Think of them as the guardrails that keep a powerful vehicle on the road. What does an organizational code of ethics look like? Nearly every organization publishes one to guide daily conduct. It may appear as a formal ethics statement or live inside the policies and procedures that run the business. When it stands alone, it is usually high level, offering broad direction rather than answers to every specific situation, and other detailed policies fill in the gaps. Consider a public sector example, where government service carries a written code demanding loyalty to country above person or party, honest effort, and refusal of favours that could sway official duties. Think of it as the mission statement for how people should behave, with detailed rulebooks sitting underneath. What does the Code of Ethics demand? It sets the standard of conduct that every certified professional agrees to uphold. It opens with a short preamble, then lays out 4 canons, and signing on to it is a condition of holding the certification. The preamble makes the point plainly that the safety and welfare of society and our duty to those we serve require the highest ethical standards. The 4 canons then guide the rest. Protect society and the common good. Act honourably, honestly, justly, responsibly, and legally. Provide diligent and competent service to those who hire you, and advance and protect the profession itself. Notice the order is deliberate. Society comes first, then your duty to clients, then the profession. Think of it as a hierarchy of loyalties, with the public good at the top. How are ethics complaints handled? Through a formal process built on the 4 canons. A member who believes a violation occurred can file a complaint, but it must name the specific canon that was breached. There is also a rule of standing, meaning only someone actually injured by the behaviour may complain. Who can file depends on the canon. Any member of the public may raise a complaint under the first 2 canons, which protect society and honourable conduct. Only an employer or someone in a contractual relationship may file under the 3rd, about service to clients. And any licensed professional may file under the 4th, about protecting the profession. Complaints come as sworn written affidavits, and violations can cost someone their certification. Think of it like a courtroom that only hears from those with a real stake in the outcome. What new questions does artificial intelligence raise? A whole new frontier of ethical responsibility. As AI systems automate decisions and interact with people, they must earn trust the way any professional must. A leading risk management framework stresses that AI must be sound and dependable, doing its job the way it is supposed to, safely and consistently. It should also be accountable and transparent, with human oversight and a clear, explainable path from data to conclusion. Organizations carry an ethical duty to hunt down and correct algorithmic bias, so their models do not quietly reinforce discrimination. To formalize all this, a dedicated management system standard lets an organization bake ethical AI principles into its governance and keep improving them. An emerging regulation now sorts AI systems into risk tiers, banning the most dangerous uses outright and demanding strict oversight of the rest. Think of it as writing a code of conduct for a colleague who never sleeps and never forgets. Which classic frameworks still guide digital conduct? Several older references remain useful touchstones, none of them binding law. The first is a foundational Internet ethics statement, issued when the network was outgrowing its original trusted community. Rather than listing what you should do, it lists what you should not, calling it unethical to gain unauthorized access, disrupt intended use, waste resources, destroy the integrity of information, or compromise user privacy. Most later codes trace their roots to this document. Think of it as the original rulebook for good behavior online, still quietly shaping the ones we use today. What does the 10 Commandments of computer ethics teach? A simple, memorable set of do-not rules for computing. Crafted by a dedicated ethics institute, it warns against using a computer to harm others, to steal, to snoop through someone's files, or to bear false witness. It tells you not to copy software you have not paid for, not to use others' resources without permission, and not to claim someone else's work as your own. It also asks you to weigh the social consequences of what you build and to always show consideration for your fellow humans. Think of it as a plain language conscience for anyone at a keyboard. What is the Code of Fair Information Practices? An early and influential blueprint for handling personal data responsibly. It rests on 5 principles. First, no personal record-keeping system should exist in secret. Second, people must be able to find out what data is held about them and how it is used. Third, information gathered for one purpose should not be reused for another without consent. Fourth, people must be able to correct records about themselves. And fifth, any organization holding personal data must keep it reliable and guard against misuse. Notice how modern these sound. They quietly underpin much of today's privacy law. Think of it as an early Bill of Rights for your personal information. So let's bring it together. Ethics matter because your access is enormous and trust is everything. Organizations publish their own codes, and the Code of Ethics binds every certified professional through a preamble and 4 canons ordered from society down to the profession. Complaints follow a formal, canon-based process, open only to the injured. Artificial intelligence adds fresh duties around reliability, transparency, and bias. While classic frameworks like the early Internet Ethics Statement, the 10 Commandments of Computer Ethics, and the Code of Fair Information Practices still guide us. Live by these, and your authority stays worthy of the trust behind it. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session.